Hi, everyone, and welcome to Crime in Court. This is the Canton cover up series, Commonwealth versus Karen Reed. We are on episode 107, Motion for Additional Vehicle Testing and Analysis. So let's get started. We are making our way through all of the many filings that have been going on, both from the Commonwealth and Karen Reed's defense team. There's been motions galore. So we're making our way through them and let's get to it. So, this, as the title suggests, there was a motion from the defense for additional testing of the Lexus, not just the Lexus, but John's Traverse, his Chevy Traverse, and also the driveway at One Meadows Avenue, which is where John and Karen was living at the time. Karen was living there part time, John and his niece and nephew living there full time. So let's read what the defense wants. So this is the defendant's rules 14 and 17 motion for court order authorizing defense access to the Lexus and Traverse and to the driveway at 1 Meadows Ave in Canton to conduct independent testing and analysis. Now comes the defendant, Karen Reed, and respectfully moves this honorable court, pursuant to Rule 14 and 17, to grant the defense access to the 2021 Lexus LX 570 as well as to the 2019 Chevrolet Traverse for independent examination and testing by defense expert witness Robert A. O'Neill Jr. So, this is a new witness that we did not see in trial one. Obviously, we didn't see very many witnesses for the defense. So, they probably have a whole lot of witnesses up their sleeve that we might not know about. But this particular expert is he provides a affidavit to support the fact that additional testing is needed. So let's see what uh, the rest of this motion says. Ms. Reed requests that this court order that Mr. O'Neill be given brief access to the collision incident locus, the driveway at One Meadows Ave in Canton, to collect necessary photographs, measurements, and scans of the area. So this footnote says our expert estimates the examination would take approximately 2 hours if they went to the location where Ms. Reed's vehicle allegedly, although with my own eyes I see that the Traverse moves in video. So I do believe that she hit John's Traverse. This is for additional testing for the driveway for both cars to find out did she or didn't she. As grounds for the motion, Ms. Reed states that these vehicles are currently and have been in the exclusive control of the Commonwealth. Justice requires that the defense have equitable access to these vehicles to create an independent scientific reconstruction of the collision. Further, Ms. Reed requests that the court issue a court order and subpoena for additional daytime footage from the home security camera. So they're trying to see if there's more footage available. Um, according to what is this? Commonwealth versus Lampron, where the SJC ruled that because Rule 17 was modeled after its federal analog, Federal Rule 17, Massachusetts should adopt the standards articulated by the federal courts regarding the issuance of a subpoena for the production of documentary evidence. So that's what they're trying to follow the letter of the law. That additional security footage will allow the defense to analyze the quality of the recordings that this camera captures more thoroughly and to compare the daytime footage with the existing dark, snowy footage of the collision. That's uh, to me, that sounds like this person knows what he's doing because he's going to be comparing, similar conditions. Mr. O'Neill also seeks brief access to Mr. O'Keefe's driveway in order to visualize the incident location, take measurements, and conduct scans of the area. This access will contribute to an accurate reconstruction of the collision incident and would help to satisfy Ms. Reed's constitutional right to present all of the necessary evidence in her defense. Factual background: Ms. Reed is accused of the following crimes arising out of the death of Officer John O'Keefe: homicide in the second degree, manslaughter while under the influence of alcohol, and leaving the scene of personal injury and death. The court understands that any evidence of a collision between the Lexus and the Chevrolet during the morning of January 29th will be crucial to reconstructing exactly what happened to Mr. O'Keefe. The Commonwealth, via the MA State Police, conducted multiple rounds of vehicle testing, processing, analysis, and collision reconstruction without informing the defense of their plans to do so. On February 3rd, 2022, the Mass State Police were given access to the driveway at Meadows Ave in order to complete forensic tests and photograph the scene. After the Commonwealth took possession of the vehicles, they conducted multiple further accident reconstructions and analyses, including as recently as July 24th, so after the trial concluded. They're still doing more accident reconstructions and analyses. The Commonwealth is. Inexplicably, the Mass State Police conducted some of these tests in the presence of the decedent's brother, Paul O'Keefe, and his friend Brandon Kane, both of whom are civilians. So why the hell were they there? That makes absolutely no sense, and I think that needs to be spoken to. Why was Paul and his friend, both civilians, present during testing done by the Massachusetts State Police? That makes no sense. And yet the defense doesn't have access to it or wasn't there. That makes no sense. So these tests were completed without alerting the defense and solely according to the Commonwealth and State Police's timelines. Here's the argument. The defense has a constitutional and statutory right of access to the vehicles, the security camera footage, and the collision location. Ms. Reed requests access to the Lexus, the Chevrolet, the daytime security footage, and the collision location. The defense has a right to access and independently test this relevant and material physical evidence. The due process clauses of the federal Constitution and the Massachusetts Declaration of Rights require that the Commonwealth disclose to a defendant material exculpatory evidence in its possession or control. Ms. Reed's right of access to this evidence is just that, a right, not a matter of discretion. According to this Commonwealth versus Neal, discussing a defendant's right of access to an independent test of evidence. Commonwealth versus Nicholson. Fairness certainly requires giving defense counsel prompt access to all materials and information in the possession of the Commonwealth and permitting tests of such materials to be conducted at public expense if necessary. So that is, well, obviously the public would pay for testing if the defendant did not have money. In this case, she is not indigent, so she is paying for her own expert. The prosecution shall disclose to the defense and permit the defense to discover, inspect, and copy material and relevant tangible objects. This right originates from constitutional law at both the state and federal levels. Federally, the right to independent access to evidence arises from the Due Process Clause of the United States Constitution, describing the Supreme Court's development of the area of constitutionally guaranteed access to evidence as a safeguard to due process rights. The Supreme Court traditionally has evaluated access to evidence claims under the protections of the Due Process Clause of the 14th Amendment. Denial of Ms. Reed's right to access and examine this evidence would therefore be an infringement of her due process rights under the United States Constitution. The Massachusetts Declaration of Rights provides similar protections. The words "the law of the land" in Article 12 embrace all that is comprehended in the words due process of law in the 14th Amendment. The Massachusetts Constitution related principles of fundamental fairness requires that Ms. Reed have access to the Commonwealth's physical evidence for independent testing. Our Constitution secures to a defendant the right to present his defense. To say that a defendant has a right to present his defense and then to deprive him of the means of effectively exercising the right would reduce the guarantee to an idle gesture. These fundamental constitutional due process rights are operationalized through the Massachusetts Rules of Criminal Procedure, Rule 14. The prosecution shall disclose to the defense and permit the defense to discover, inspect, and copy material and relevant tangible objects. Commonwealth's duty to disclose exculpatory evidence to criminal defendants is further reflected in our Rules of Criminal Procedure and Rules of Professional Conduct. The two vehicles, daytime security footage and driveway, are all material and relevant evidence that is critical for Ms. Reed's defense. Ms. Reed is entitled to fair and independent access to this evidence under the United States Constitution, the Massachusetts Constitution, and the Massachusetts Rules of Criminal Procedure. Commonwealth claims that pieces of the right taillight of Ms. Reed's Lexus broke off and were left at 34 Fairview Road on the night of Mr. O'Keefe's death. Security camera footage from One Meadows Ave shows the back of Ms. Reed's Lexus colliding with the parked Chevrolet early in the morning of January 29, 2022. Whether the Lexus taillight was broken in that collision is crucial evidence and material to Ms. Reed's defense. Ms. Reed has a fundamental right to access these vehicles' daytime security footage from the same home security camera and the location of the collision in order to conduct independent forensic testing. Further, in light of the state police's unexplained choice to have the decedent's brother and friend, both civilians, present during official forensic testing, Ms. Reed respectfully requests that any members of the Commonwealth's team, and especially the O'Keefe family, not be permitted within 200 feet of the vehicles while the defense expert, Mr. O'Neill, conducts his test analysis. Interesting, huh? How close were Paul and this other person when the Mass State Police were testing? And what were they testing? And were they looking at the traverse? And did Paul touch the traverse? Or did, as rumor has it, someone go and fix the traverse? So all these things need to be independently analyzed. Ms. Reed understands that it may not be possible to conduct a fully independent testing because the vehicles are in the custody of the Commonwealth, but fairness requires that this analysis be kept private from those who might want to prematurely glean insight from our findings. Regarding access to the traverse and the driveway at One Meadow Ave, the defense has met the requirements of the Rule 17. The Supreme Judicial Court in Commonwealth versus Lampron, as quoted in Commonwealth versus Dwyer, established 4 criteria a defendant must satisfy when seeking the production of materials under Rule 17. The party moving to subpoena documents to be produced before trial must establish good cause satisfied by a showing that the documents are evidentiary and relevant, that they are not otherwise procurable reasonably in advance of trial by exercise of due diligence, that the party cannot properly prepare for trial without such production and inspection in advance of trial, and that the failure to obtain such inspection may tend unreasonably to delay the trial, and that the application is made in good faith and is not intended as a general fishing expedition. So I believe they met all of those 4 prongs. Once the 4 criteria are established by a motion and accompanying affidavit, the court deciding the motion follows the remaining Lampron-Dwyer protocols. Here, all 4 criteria have been established. See David Yannetti's affidavit, which we will read. Conclusion: for the foregoing reasons, and in the interest of fairness, Ms. Reed respectfully requests that the Honorable Court grant her motion in limine for access to the above mentioned vehicles, the home security camera footage, and the locus of the collision incident. And that was dated February 11th. We have the affidavit of Robert O'Neill. This is the expert doing the testing. He says, I am an ACTAR accredited an accident reconstructionist. I am employed at As is, we'll say, Incorporated, an engineering consulting firm that specializes in accident reconstruction and video analysis. I have been working in this capacity at As is for approximately 29 years. I was asked to consult with the defense regarding the above captioned matter to investigate and review the ring camera footage that depicts the interaction that took place between the Lexus and the Chevy Traverse in the driveway of One Meadow Ave. To perform this video analysis, I will need to have 3D measurements for the site where the incident occurred without snow being present. I can perform this analysis using the laser scan data collected previously by Aperture. Alternatively, As is personnel would need to enter the driveway of One Meadows Ave in Canton at a time when there is no snow covering the driveway or a, a appurtenances? I don't know what that means. What is appurtenances? Um, I would assume like things in the way, obstacles. And the surfaces are dry. They are looking for dry. Let me look up appurtenances, if I'm even saying that right. An appurtenance is an accessory or other item associated with a particular activity or style of living. So I'm assuming like nothing, don't park anything in the driveway is what that means. We would set up a 3D scanner in multiple locations in the driveway. We may also need to take measurements separate and apart from the 3D scanner, along with photographs and video of the site. I estimate that the investigation and work in the driveway would take approximately 2 hours. To conduct an accident reconstruction regarding this matter, I will need 3D measurement data and photographs for the exterior of both vehicles. I can perform the initial alignment analysis with the laser scan data and photographs collected previously by Aperture. Alternatively, As is personnel will need to perform a 3D scan of the exterior of both vehicles. We may also need to take measurements separate and apart from the 3D scanner, along with photographs and video of the site. To recreate the circumstances that existed on January 29th, they may need to fill the tires of one or both vehicles with air, assuming that the vehicles are located on the flat surface in the same place with a minimum of 15 feet clear around each vehicle, and while both vehicles are dry. I estimate that my investigation and data capture would take approximately 2 hours. And it is signed by Robert O'Neill. David Yannetti also submitted an affidavit saying, I do hereby depose and state that the following is true to the best of my knowledge and belief. I am the defendant in the above captioned matter. I am an attorney licensed to practice in Massachusetts since December 1989. On January 29th, 2022, I was retained to represent Karen Reed, the defendant in the above entitled matter. The Commonwealth, uh, that first one is like throwing me off. I don't think he meant I am the defendant. I think he meant I am the defendant's attorney or something. I don't know. That's been throwing me off since I read it. Okay. Now that we are past that, the Commonwealth has provided notice to the defense that it has retained an expert to examine and perform tests related to my clients, Lexus and Mr. O'Keefe's Traverse. The defense desires the same opportunity to have an expert conduct independent testing. Commonwealth has also provided notice to the defense that it has retained an expert to examine and conduct tests in the driveway of 1 Meadows Ave in Canton. The defense desires the same opportunity to have an expert conduct independent testing. The defense should have the same opportunity to conduct testing that the Commonwealth has. It should not matter that one of the vehicles and the driveway in question are not in the Commonwealth's custody. This motion is thereby brought in part pursuant to Rule 17. The Lexus and the Traverse, as well as the driveway at 1 Meadows, contain information that is both evidentiary and relevant to the issues in this case. The Commonwealth had complete access to both vehicles in order to perform testing. Both vehicles are relevant to the case. The Commonwealth alleges that the Lexus in their possession struck and killed Mr. O'Keefe, causing the Lexus rear tail light to shatter outside 34 Fairview Road in Canton. The defense denies the allegation and believes that the Lexus instead struck the Traverse in the driveway of 1 Meadows, causing the taillight to break there instead. Both vehicles therefore contain evidence that is relevant to both the prosecution and the defense. Only the prosecution currently has access to both vehicles. Access to the vehicles and the driveway is not otherwise procurable reasonably in advance of trial through the exercise of due diligence. Traverse and the driveway at 1 Meadows are in the possession of a third party, the O'Keefe family. My co-counsel has represented the Commonwealth has requested the Commonwealth to inquire of the O'Keefe family to grant the defense access to the Traverse, while I have asked the Commonwealth to inquire of the O'Keefe family to grant the defense access to the driveway. Excuse me. The defense has also been told to file the appropriate motion before the court in order to obtain access to either or both. They've been told by Hank, file a motion. Don't ask me for anything. File a motion, which in reality, most attorneys should like work with one another before like filing all the motions and things. They should, hopefully they can work things out without the motions. That doesn't always work, especially when you've got a Commonwealth who basically wants to object or oppose every single thing the defense does. The defense cannot prepare for trial without the ability to examine, inspect, and conduct testing on the vehicles and the driveway, and the failure to obtain and inspect the vehicles and the driveway will unreasonably delay the trial. The issue of how the tail light of the Lexus cracked or broke is a paramount issue at this trial. One party cannot have full access to conduct whatever testing is necessary while the opposing party is prohibited from conducting its own testing. A denial of this motion will impair the ability of the defense to cross-examine Commonwealth witnesses and to present in full defense at trial. This issue is so important that a denial of this motion will likely necessitate an interlocutory appeal. So they're already warning you, like, if you object to this, if you deny this, we will take this up with the SJC, which will further delay the upcoming trial date. And you know how Judge Canoni was all gung ho on April 1st being the date. But now that the Karen Reed team has filed federally a motion regarding her double jeopardy protections, that I don't think that they're going to trial on April 1st at all. All right, so this motion is made in good faith and is not intended as a fishing expedition. The defense is not speculating about whether the vehicles and the driveway contain relevant evidence. The Commonwealth agrees that relevant evidence will be found on the vehicles and the property as that is why they accessed the vehicles and the driveway to conduct their own testing. In good faith, the defense needs access to the vehicles in the driveway to conduct the specific testing that needs to be done in this case. For the foregoing reasons, I would respectfully request that this honorable court allow this motion. And we have a response from the O'Keefe family. This is an affidavit from their attorney. I, Mark A. Diller, do hereby depose and declare the following on behalf of the family of decedent John Joseph O'Keefe III for the court's consideration with respect to defendant Karen Reed's motion for for an order granting unfettered access to the O'Keefe family's private property. I, Mark Diller, am an attorney licensed to practice law in the Commonwealth of Massachusetts, and I represent the O'Keefe family in a civil wrongful death action against Karen Reed that is currently pending in Plymouth Superior Court. Paul O'Keefe as personal representative of the estate of John O'Keefe and C.F. McCarthy's and all those other people they're that are on the civil suit. So I am filing this affidavit on behalf of the O'Keefe family in response to the defendant Karen Reed's motion for a court order granting access to the O'Keefe's private residence, security footage, and vehicle, the Traverse, for examination and testing by defendants with expert witness Ms. Reed seeks an order permitting her expert witness, Robert O'Neill Jr., to enter the O'Keefe family's private premises in order to visualize the incident location, take measurements, and conduct scans of the area. Ms. Reed also seeks permission to inspect and to perform measurements and analysis of the O'Keefe's Chevy Traverse, which may require filling the tires with air. Significantly absent from Ms. Reed's motions are any proposed constraints, protocols, or external controls regarding the defense team's access to and forensic testing of the O'Keefe family home, security footage, and private vehicle. In addition to unfettered access to the O'Keefe private property and family home where two juvenile children currently reside, Ms. Reed asks this court to order that any member of the Commonwealth's team and especially the O'Keefe family, not be permitted within 200 feet of the vehicles during the forensic testing. And there's a footnote here. Assuming the defense expert intends to perform the vehicle forensic testing analysis in the driveway of 1 Meadows Ave, the requested contingency would restrict the O'Keefe family from remaining in their own home during the analysis, of which there is no self-imposed time limitation. Well, they can leave the property for 2 hours. Seriously, that's not that big of a deal. What else does it say? All right, so as a preliminary matter, the Commonwealth's duty to provide access to evidence pursuant to Rule 14 applies only to such evidence that is within the possession, custody, or control of a member of the prosecution team. Here, the evidence Ms. Reed seeks to access is private property within the exclusive possession and control of a grieving family who are not a party to this criminal proceeding. Nevertheless, in the pursuit of truth and justice on behalf of John O'Keefe, his family agrees. Didn't see that one coming, did ya? I didn't. But the O'Keefe family agrees to accommodate defense counsel's request for access as it pertains only to the driveway of the private property and with the condition that the defense team's admittance is not without guardrails and supervision. The principles of equity and fairness resonate throughout Ms. Reed's motion. The O'Keefe accept Ms. Reed's fundamental right to evidence in order to prepare her defense. However, Ms. Reed's rights should not unnecessarily infringe upon the privacy and property rights of the O'Keefe family, which are also protected by our Constitution. The O'Keefe family has a right to ensure that members of Ms. Reed's defense team conduct their activities in a professional and respectful manner while given access to the driveway. What do you think they're going to be doing? While given access to the driveway of the family home and vehicle without overreaching or causing damage to their private property. Therefore, in the interests of fairness, the O'Keefe family respectfully requests that this court reject Ms. Reed's request that the O'Keefe family not be permitted to be present during any testing or analysis of their home or property. I think that's BS. I think they could have left the property for 2 hours. It's not really that much to ask, but whatever. At least they're allowing the testing to be done. Alternatively, the O'Keefe family requests permission to have an independent observer present to supervise the defense team during evaluation of the Chevy Traverse and at One Meadows Ave. Such independent observer might include a family friend, neighbor, a police officer from an adjacent county who was not involved with a criminal investigation or some other uninterested third party proposed by this court. Permitting an independent observer, hold on, it's going to get loud. Permitting an independent observer to be present with the understanding that he or she will not interfere with the defense testing addresses any concern of bias and allows the defense expert access to the requested evidence while protecting the interests of the O'Keefe family. Regarding the security footage requested, it is difficult to respond in a vacuum to such a broad and ambiguous request. However, the O'Keefe family agrees to provide the taped security footage obtained of the Reed team's evaluation of the One Meadows driveway that appears to satisfy their request. I am not available to appear in court on the 18th. I, Mark A. Diller, certify under the penalties of perjury that the foregoing is true and correct to the best of my knowledge and belief. And that is the end of that. So let me know what you guys think in the comments below. At least the testing is going to be conducted. It may not be, totally independent of the O'Keefe family, but at least they're able to do it. So that is a win for the defense. And they're agreeing to hand over the ring footage. So that's also a win. And they didn't have to go through, court orders and whatnots. So that was at least for once like something isn't being totally objected to by the Commonwealth. This is the O'Keefe family, so it's not the Commonwealth to be doing the objecting, it's the O'Keefes. But all right, let me know what you guys think in the comments below, and I will see you guys in the next one. Take care. Bye now.